Bill 2361, and we'll call upon Natalie to inform us of the content of this bill.
Mr. Chairman, I'm sorry, I didn't start hearing you until the middle of your remarks. Which bill did you call it?
You probably missed the best part of my remarks because I usually say something clever at the beginning, but it would be House Bill 2361.
Okay, I'll go back and listen to the YouTube stream, see what you said. So House Bill 2361 authorizes the Supreme Court to adopt rules establishing specialty courts and creates the Specialty Court Funding Advisory Committee and the Specialty Court Resources Fund. New Section 1 requires the Supreme Court to adopt rules for the establishment and operation of one or more specialty court programs within the state. A chief judge of a judicial district may establish a specialty court program in accordance with those rules. Subsection B establishes a specialty court funding advisory committee. That committee would be responsible for evaluating resources available for assessment and treatment of people assigned to specialty courts. They would try to secure grants, funds, and other property and services necessary to facilitate the operation of specialty courts, and recommend to the judicial administrator the allocation of resources among the various specialty court programs across the state. They would also be charged with recommending legislation and rules to aid in the development of specialty court programs. The committee shall consist of the chairs of the Judicial, of the House of Representatives and the Senate, the chair of the Legislative Budget Committee, one member of the legislature appointed jointly from both the minority leader in the House and the Senate, 5 members appointed by the Chief Justice, including a prosecutor and a criminal defense attorney. And then the committee would have 3 ex officio non-voting members. One would be appointed by the Secretary of Corrections, one appointed by the Secretary for Aging and Disability Services, and a drug and alcohol addiction treatment provider who would be appointed by the Kansas Sentencing Commission. The bill outlines the terms of the members and provides that the Chief Justice shall designate the chairperson of that committee. The Office of Judicial Administration would provide technical assistance as requested by the committee. The members would receive certain compensation, travel expenses, and subsistence allowances as provided in that section there. Nothing in the section would prohibit any judicial district, local government, or the judicial branch from directly applying for funding to facilitate the operation of specialty courts. And any funding that would be obtained by those groups independently of the committee would not be remitted to the state treasurer in accordance with this section. The bill also creates the Specialty Court Resources Fund to be administered by the judicial administrator. All expenditures from that fund would be for the purpose of operating specialty court programs, and funds acquired by that committee that is created in this section would be remitted to that fund. If a person is sentenced to participate in a specialty court program and successfully completes that program, then the person's sentence would be able to be reduced or modified, but it can't be modified or reduced below a minimum sentence that would otherwise be required by law. This section also provides a definition of what constitutes a specialty court. Section 2 amends KSA 216604 to provide that ordering a defendant to participate in a specialty court program is an authorized sentencing option when the person has been found guilty of a crime. Section 3 amends KSA 216614 to provide that a person who has completed the requirements of a specialty court program and would otherwise be eligible to have records expunged under subsection B, C, D, E, and F would be able to petition the district court for expungement of the related conviction and arrest records. The court may waive all or part of the docket fee imposed for filing that petition. At the hearing on the petition, the court shall order the petitioner's records expunged if the court finds that no proceeding involving a felony is presently pending or being instituted against the petitioner. The circumstances and behavior of the petitioner warrant the expungement, and the expungement is consistent with the public welfare. And I can take any questions.
Natalie, committee, any questions? I don't see any, so we will proceed then with proponent testimony. We'll welcome and call upon Judge Glenn Brown, Chief Judge of the 23rd Judicial District. Judge Brown, welcome.
Thank you, Mr. Chairman. I appreciate the opportunity to be here today. I was the district judge designee to the Criminal Justice Reform Commission. I see Representative Owens is present. He's a member of that commission along with Representative Finney. This is one of the proposed bills that the committee endorsed and resulted in our hearing today. As you all probably are aware, the Criminal Justice Reform Commission, one of the statutory duties was to study specialty courts, and this is the resulting proposed legislation. Specialty courts exist in Kansas and have for some period of time. I checked, we have currently about 21 specialty courts in the state. Those are currently in 14 of the judicial districts, 14 of the 31. I think one of the reasons that I was asked to participate in the Criminal Justice Reform Commission and look at specialty courts is we're one of the newest specialty courts in Ellis County. We started about 3 years ago. Our biggest challenge in starting the specialty court was to get the initial funding to properly staff and equip the court. The members of the Ellis County Drug Court are all currently employed, but we had to obtain a defense attorney to sit in on the specialty court, our drug court, and that was where our initial costs were associated with, along with some incidental office supplies and a computer. Fortunately for us, our Ellis County Commission had the foresight and to award us an initial grant. Current Representative Barbara Wassinger was a member of that commission and took a keen interest in our drug court and assisted us in getting started. Since then, we went through the ordeal of applying for federal grants to provide additional funding. Most of the specialty courts in Kansas are federally granted funded courts, and we're one of those. That is quite a task. It took several of our members a lot of hours to prepare the Bureau of Justice grant application, and it does take a lot of manpower simply to administer that grant and provide the accounting required by the Bureau of Justice. So one of the reasons we proposed this legislation is in hopes of getting the assistance at the fed or at the state level to assist with the funding and accounting associated with that. And I think that would assist other districts that are looking to commence or start a drug court to give them a resource. Since we started our drug court, I have had 3 different districts contact me, come out and observe our drug court, visit with our drug court team, because they're interested in starting one themselves to gain information. If we would form this committee that the legislation proposes, they would then have the resource and assistance they need to start these drug courts. I don't know if anybody on the committee has ever observed a drug court or a specialty court. They are a therapeutic or problem-solving type court. It's much different than a typical hearing or court that you might be familiar with, but the benefits are tremendous, and the success. We've had 3 graduating classes already. We have a 4th that will be next month, and to see the change in the individuals that first come into drug court and to see them at graduation makes the team, the drug court team that works with these individuals, it just gives us such a sense of satisfaction, and there is a tremendous benefit to the community and to the court system. So I like all specialty court judges are enthusiastic fans of specialty courts, and we are hopeful that your committee will approve House Bill 2361. I'd be happy to answer any questions anybody might have regarding specialty courts to the extent I can. Thank you for your time today.
Thank you, Judge. Thank you, for the work you do every day and your work on the Criminal Justice Reform Commission. You've brought an important perspective to that process, I know. Committee will open for questions of Judge Brown. I'd just like to ask one to start with. And I haven't read this over in detail. You've talked quite a bit about drug courts. When I think of specialty courts, I think there's two other cohorts of specialty courts that you hear about periodically would be a mental health court, those that suffer from some form of mental health disorder that has an implication on their criminal behavior, and also veterans courts. Could you speak to those in terms of the context of this bill or otherwise?
Well, this would include all types of specialty courts. I default to drug court because that's what I do as a district judge, but you're correct. There are mental health courts in Wichita, and I believe in Johnson County. There is a veterans treatment court in Johnson County. Former Chief Justice Nuss has become very involved in establishing additional veterans treatment courts in the state. And the current Chief Justice Lukert has assisted in several webinars that have occurred already for those districts that are interested. But again, mental health courts, veteran treatment court, they have family court, juvenile, drug court, all of those are therapeutic treatment type courts.
Thank you for that. Committee questions for the judge? Anyone in the room? Anyone online? I don't see any questions, Judge. I want to thank you so much. Oh, I'm sorry, Representative Wheeler. There's one.
Thank you for your presentation, Your Honor. How are the roles of the prosecutor and the defense counsel in a drug court different than what they are in a regular judicial proceeding?
It's an excellent question. You being a former prosecutor, I sometimes refer to our prosecutor and defense attorneys as somewhat glorified social workers. They assist the participants in a lot of ways. Our prosecutor, as well as our defense attorney, have helped our participants in reobtaining their driver's licenses, assisted in directing them on how to handle their child support obligations. So they fulfill a lot of roles. However, if one of our participants violates the terms of their probation and there is a motion to revoke, they're given the option to use the drug court defense attorney at the revocation hearing, and the prosecutor steps in and fulfills their role, more traditional role regarding revocation or modification of probation.
Thank you, Your Honor.
Any other questions? I do not see any, Judge. Thank you so much for your time today and your testimony. Appreciate it.
Thank you, Mr. Chairman. Appreciate it.
Committee, the other proponent testimony that we have today is written only by Raymond, Director of Tribal Court Programs of the Office of Judicial Administration. Are there others appearing that would like to testify in support of House Bill 2361? I see none. I have no opponent testimony listed. Anybody wishing to testify in opposition? See none, and no neutral listed. Anyone wishing to testify in a neutral way on the bill? And I see none. Therefore, we will go ahead and close the hearing on House Bill 2361. And committee, I would just say you should expect to see this, I think, probably Thursday. We will proceed to work this bill, get with the reviser if you have any thoughts about any amendments or anything else. We'll move on then to the second bill on the agenda for this afternoon hearing would be House Bill 2346. We'll call upon the reviser to inform us of the content of House Bill 2346. You're able to hear all of that, all right? Is that right, Natalie?
Yes, I was.
Very
Thanks,
good.
Mr. Chairman. House Bill 2346 allows release of defendants to a pretrial supervision program and allows fees associated with the program to be deposited in the non-judicial salary adjustment fund. Section 1 amends KSA 222802 to provide that a magistrate may place a person under the supervision of a pretrial supervision entity or program to assure appearance of the person for preliminary examination or trial. That magistrate would be able to order the person to pay for costs associated with that supervision, which may be remitted for deposit in the non-judicial salary adjustment fund at the discretion of the chief judge in that judicial district. The defendant may petition the court to waive payment of the costs assessed in whole or in part for a good cause shown. Section 2 amends KSA 22-2803 just to make technical cleanup to some of the subsection references in KSA 22-2802. Section 3 amends KSA 22-2814 to authorize a pretrial supervision program or entity to administer release on recognizance programs and supervised release programs. Section 4 amends KSA 22-2618 to include a pretrial supervision program or entity in the supervision groups who shall prepare and submit recommendations to the court for supervision conditions of the defendants that are under their supervision. This section also requires the defendants to be closely supervised by such pretrial supervision program or entity having responsibility of supervising that defendant. And I can take any questions.
Committee questions for the reviser, Representative Owens.
Thank you, Mr. Chairman. Natalie, when I was reading through this bill, doesn't this also expand who can do the pretrial supervision? I think currently that's court services, but this actually expands it to allow it to be done by organizations outside of that. Is that correct?
Mr. Chairman, yeah, so most of the references to supervision of pretrial throughout the statutes are court services officers. So that is who does that supervision right now. And so those changes in section 1, specifically in KSA 22-2802, if you look at the current law there, at the bottom of page 1, starting at line 35, one of the current options in law is to place the person under supervision of a court services officer, monitoring that person's compliance. And so this would add the pretrial supervision entity or program.
That answer your question?
Thank you. Thank you, Natalie. Thank you, Mr. Chairman.
Great. Committee, other questions for the reviser? Seeing none, we will proceed with proponent testimony. We'll call upon Sean Jurgensen, Special Counsel to Chief Justice. Marla Lukert, I think, instead of Lawton Nuss, is probably incorrect on this. At least it's dated, if nothing else. Sean, go ahead.
Thank you, Chairman Jennings and member of the committee, for allowing me to appear today as a proponent conferee on HB 2346. I'm Sean Jurgensen with the Kansas Judicial Branch, and I don't have a lot to add from Natalie's portion explaining what the bill would do, but just addressing the 3 prongs that the bill would update the statute on in turn. First, on allowing a chief judge to remit the $15 per week pretrial supervision fee, either in whole or in part, to the non-judicial salary adjustment fund. Currently, there is not a statutory mechanism available for us to route that funding to the NJSA fund so that it can be used for CSO salaries. As many of you know from our budget discussions, the judicial branch is in dire need of additional CSOs. The Supreme Court commissioned a CSO weighted workload group, and the purpose of that group was to examine the statutory duties that CSOs must perform statewide. And that's before even accounting for organically arising tasks or duties that occur judicial district by judicial district. And the threshold conclusion of that report is that we don't have enough CSOs in the system to adequately perform our statutory duties. And this new optional avenue would allow for those pretrial supervision fees that are being collected to be remitted to the NJSA fund to be used for some CSO salaries. Now, don't get me wrong, it's certainly not going to cure the need for 70 additional CSOs. There's not that much to cover that. But it will help in certain parts of the state, or it could help in certain parts of the state. And so we're asking for that ability to do that. On the waiver language that Natalie discussed, it would simply provide for an individual to affirmatively request that the judge waive the pretrial supervision fee. This is one of the recommendations of the Pretrial Justice Task Force that penned its report last fall. And so based upon that report, we thought it was the best practice to codify affirmative waiver language in the statute. And so that's why we included that provision. And then expanding the pretrial supervision entities portion. In short, yeah, the bill would expand the providers who are eligible to conduct the pretrial supervision. And this would give district judges more statutory flexibility to address in situations in which other entities have the capacity to offer that pretrial supervision, even when CSOs can't. And so those are the three prongs, Mr. Chair. And again, I appreciate you and the committee's time, and I'm happy to stand for any questions you may have.
Otherwise, we have written only testimony of Chief Judge Kelly Ryan for the 10th Judicial District. I commit that for your consideration. Ask if there are any questions for Mr. Jorgensen. I see no hands raised. We will then proceed with opponent testimony and call upon Shane Rolfe, Executive Vice President of the Kansas Bail Agents Association. Shane?
Thank you, Mr. Chairman. Yes, I am Shane Rolfe. I'm the Executive Vice President of the Kansas Bail Agents Association. In its current format, KBAA is opposed to the language in the bill, or at least some of it. As Mr. Jorgensen indicated, we agree that the bill does seem to do three things. It expands pretrial supervision to entities beyond simply court services officers, although I think it's pretty vague about what that expansion might be. Have the potential to redirect proceeds to the judicial branch from the programs currently, and it provides for a waiver of fees. I guess our primary concern is the notion of expansion to entities. We are exposed to expanding pretrial supervision to we're opposed, not exposed, to expanding pretrial supervision to others beyond court services officers. This is a recommendation from the Pretrial Justice Task Force. Page 62 states that the sole purpose of this recommendation is to recognize current practices in some districts, which basically means there's districts that are operating outside the statutory pale right now. One of the concerns we have about the language of pretrial supervision entity or program is it's extremely vague. It could mean virtually anything. The Pretrial Justice Task Force indicates that most jurisdictions, I think it was 78%, do use CSOs, but some use private house arrest companies, community corrections staff, or even the sheriff's office to conduct pretrial supervision. Language this vague, rather than specifying that we could be court service officers or community corrections or something along those lines, would allow for an expansion that goes well beyond simply the examples that the Pretrial Justice Task Force use as entities that are currently providing that. And we would be concerned about what sort of protections there are for the defendant when you move that beyond court services officers who are judicial branch employees. Part of that reason being, we don't think that pretrial defendants should be subject to supervision by the same branch of government that's trying to convict them. It seems to be an inherent conflict of interest. Like I said, court services officers are judicial branch employees and accountable to the court rather than being accountable to the sheriff or the prosecutor or the local county government. From a criminal defense standpoint, which really isn't our bailiwick, but feel we need to point out, it's probably a conflict in that oftentimes pretrial services becomes personally involved with the defendant as far as what their situation is. Does it address issues like their mental health, their medical issues, their psychiatric problems, substance abuse issues? All those things could be part of pretrial supervision. However, those things also might have an impact on the defendant's criminal defense to the charges against him. And it should probably be, if we're going to expand this beyond the judicial branch, there should probably be some protections put in place that any information that's passed along in these sorts of meetings doesn't get transferred to law enforcement or the prosecutor's office or something along those lines that could be used against the defendant to his detriment in a criminal proceeding. To that point, I mean, one of the first things any criminal defense attorney says is, don't talk to anybody. You have the right to remain silent. Make sure you exercise it. But how's that going to work when a pretrial supervision entity can demand that the defendant talk under threat of incarceration? Those situations where the program is being operated by the sheriff's office, I would assume that in many of those instances, other members of that same sheriff's office are the ones that initiated the prosecution against the defendant. You can certainly foresee a situation where a court services officer, or not a court services officer, but a pretrial supervision entity would demand that the person that they're supervising speak with law enforcement or provide some additional information that might not be in that person's best interest. We also think that pretrial supervision has always been sort of an unstated or maybe unintended attack on surety bail, which is what we do. All the organizations who write the best practices for this sort of stuff, people like the Pretrial Justice Institute, they have it in their mission statement, the elimination of commercial bail. So when you see someone's best practices of how to handle pretrial supervision, oftentimes it is seen as a replacement for surety bail, which obviously from our perspective would be a problem. We just think that if you expand beyond that to beyond court services, you're going to open the door more to allow these types of groups to provide grant funding, for instance. Not that that's a bad thing, but that grant funding comes along with strings attached that you will not use bail bonds or that you'll move a program away from traditional surety bail. Now, the Pretrial Justice Task Force also points out in page 58 that pretrial supervision is best when it's not overly invasive. Over supervision leads to failures both in compliance and in appearance. And we think that expansion of pretrial outside the judicial branch will likely lead to over supervision, thus increasing failures to appear. Pretrial services programs currently operating across the state of Kansas have non-compliance rates in excess of 30%. Non-compliance typically results in warrants being issued. Defendants with active warrants for non-compliance, knowing they're going to be placed into custody, if they appear like they're supposed to, fail to appear at a much higher rate. Now, there's some argument over how exactly those numbers are being tabulated, but there is 30 to 35% non-compliance or failure to appear combined in the current programs that we have now. But this means that at least a third of the defendants on supervision have an increased incentive to abscond because they're looking down the face of being placed back into custody because they've somehow violated some condition of their pretrial release. Those signature bonds already have a failure to appear rate almost twice that of surety bonds. This is coming from the Bureau of Justice Statistics that studied, I think it was 750,000 criminal cases over the 75 largest jurisdictions, found that surety bonds had a failure to appear rate of about 18% versus signature bonds that had a failure to appear rate in excess of 30%. And what we've seen a lot with COVID here of late is that those numbers, as we've seen emergency releases and other sorts of lenient releases due to COVID issues, those failure to appear rates are really pretty much lining up with what that Bureau of Justice Statistics study showed years ago. Pretrial supervision and house arrest are both only statutorily permissible conditions for defendants to assure appearance. KSA 22-2002 requires the judge set a bond in an amount, specify amount, that will reasonably assure both appearance and public safety. However, the statute only allows for these additional conditions, house arrest, pretrial supervision, to assure appearance. Since there's really no other statutorily permissible reason to require these conditions, this means that essentially in order to place a person on supervision or to place a person on house arrest, the magistrate has already determined that these defendants are at increased risk of flight. Now, the Pretrial Justice Task Force also says that money bond relates solely to risk of flight. Now, they use money bond as secured bond. We prefer the term secured. And we disagree with that. We think that secured bail has applicability in both appearance and public safety, as for the first sentence of the statute. But even if that's accurate, the conclusion that one would have to draw is that financial bail or secured bail is appropriate and probably required when the defendant is a flight risk. And conversely, that non-financial personal recognizance bonds should not be appropriate for someone who is determined to be a flight risk. Given that these defendants are already deemed to be flight risk by virtue of the requirement of pretrial supervision, which is only there to assure appearance, any expansion of pretrial services should be accompanied by a restriction on eligibility for personal recognizance bonds for those subject to these conditions. In short, a person who is a flight risk should be required to post a meaningful bail. We have attached a proposed amendment that would make it clear that a personal recognizance bond is not permitted under these circumstances. We hope that the committee will consider that when it works the bill. Now, as far as the supervision proceeds, it could be problematic, and it does seem like it is an attempt to bolster or somewhat offset some of the expenses in the judicial branch budget. And it does make sense that the proceeds generated by court services officers by conducting pretrial supervision should go into the fund that helps pay for court services officers. However, I don't know that it makes a whole lot of sense when you're talking about expanding this beyond court service officers to other entities, that should the court service officers non-judicial salary adjustment fund then be given the funds that they're not expending. Further, these fees are not simply the $15 a week that's been referenced and that's referenced in the statute. There is a catch-all to allow any additional additional expenses. In 2011, the State v. Gardner, the Supreme Court kicked back saying that the statute only allowed for the $15 a week. And so less than a month later, a bill was filed that the legislature adopted, modifying 2220 to allow for pretrial expenses to include any other expenses incurred as part of supervision. And that was argued to be part of things like house arrest, evaluations, urinalysis. I think the Pretrial Justice Task Force basically says that those also include things like house arrest fees, GPS fees, urinalysis fees, RBU or SCRAM fees for remote alcohol monitoring. These funds run into the millions of dollars statewide. As a crude example on how that works, Johnson County, whose budget is available online, spent $2.8 million on its house arrest program in 2019. It recovered $1.8 million in fees from defendants, obviously still leaving the program operating at a deficit, but still they recovered almost $2 million. Assuming that even half of that, which I think is low, of the house arrest program was for pretrial, that's an extra $1 million. That's not $60 a month. That's a substantial amount of money that would be siphoned away from Johnson County, or potentially siphoned away. I know there's a discretionary aspect of if the chief judge can send that money elsewhere, and that's going on all over the state. So I mean, we're not just talking $60 a month per defendant. We're talking substantial sums of money that your local jurisdictions would end up having to foot the bill for if that money was transferred to the judicial branch non-judicial salary adjustment fund. We are concerned that funneling this money there could make bond supervision a revenue source for the judicial branch, which then creates potential conflict in judicial decision-making, particularly if the Supreme Court were to adopt an administrative order directing increased use of bond supervision, or increase that money goes directly into that fund rather than at the discretion of the chief judge. We can't imagine that most local governments would want to pay for all the expenses associated with this, while any fees recovered were siphoned off to the judicial branch. More likely, they would simply decline to provide the option of court service or pretrial services if they weren't able to recover any of their costs associated with that, particularly in smaller districts. As far as the waiver of cost issue, this doesn't really directly impact Kansas bail agents. It could, however, have a negative impact on smaller jurisdictions who rely on private contractors for services like house arrest. A lot of times those house arrest programs that are offered by private providers in these smaller districts have an arrangement either to collect the fees from the district itself or from the defendant as the case is ongoing. However, if those fees could be retroactively waived, private providers will probably either bow out of the option of providing that or expect compensation directly from the local government. Now, obviously, places like Johnson County that are already running $1 million deficit on their house arrest programs, they don't care. They provide all that service in-house. But smaller jurisdictions may not have that option, and that's probably something to consider. So I'll conclude here that while we're opposed to the expansion of pretrial supervision beyond the judicial branch for various reasons we put in here, we do suggest that if such an expansion is contemplated, it be accompanied by restrictions on personal recognizance bonds for defendants who, by virtue of the supervision requirement, are already deemed to be flight risk. Having a secured bond for these risky defendants will help ensure that they return to court to answer the charges against them. The amendment we have proposed, which I noted we attached here too, will help solve that problem. So thank you for your time and consideration on this. I'll be happy to answer any questions.
Mr. Rolfe, committee, any questions? This would be the only opponent testimony I think we have. I don't see any. Thank you, sir, for your testimony. Is there any other person wishing to testify in opposition to House Bill 2346? I see none. We have no neutral testimony listed. Anyone wishing to testify neutral on the bill? I see none. We will close the hearing on House Bill 2346. Committee should contemplate again seeing this bill likely on Thursday for consideration at that time. Get with Natalie if you have any requests. We're going to move on now to hearing on House Bill 2374. We'll call upon the reviser to inform the committee of its content. Natalie?
Thank you, Mr. Chairman. House Bill 2374 authorizes the Kansas Sentencing Commission to change risk assessment cutoff levels for participation in the Certified Drug Abuse Treatment Program, what we commonly refer to as the Senate Bill 123 program. Current law in KSA 216824 provides that a criminal risk and needs assessment shall assign a high or low risk to an offender. And if that offender is assigned high risk status on a drug abuse assessment and moderate or high risk on the criminal risk and needs assessment, the offender qualifies for participation in that Certified Drug Abuse Treatment Program. Section 1 of this bill would amend that to allow participation based on criteria determined by the Kansas Sentencing Commission. Section 2 amends KSA 755291 to provide that offenders who are determined to be an appropriate risk level as determined by the Kansas Sentencing Commission may be supervised by community correctional services. Current law in that statute requires the offender to either be moderate, high, or very high risk on that risk and needs assessment in order to be supervised by community correctional services. And I can take any questions.
Any questions for Natalie? Natalie, just one quick one. If the Sentencing Commission were to alter the level at which one would become eligible for the Senate Bill 123 services, would they necessarily be limited in providing those services by virtue of the appropriation that they receive to provide such services? Or would this be something that we end up funding, at any level?
Mr. Chairman, so this is one qualification to participate in the Senate Bill 123 program. You'll also recall that the program sets out what grid boxes the offender has to be in. So that qualification in order to participate isn't changing. You still have to be convicted or sentenced, and the classification has to be in one of those grid boxes. So this is just tinkering with the risk and needs assessment. And so I didn't look at the bed impact statement. Obviously, Scott's going to testify, but I don't know that it would result in too much change to who would be eligible to participate in the program.
That's great, thank you. We'll just let Scott answer the rest of the question then. And we'll go ahead and call on Scott Schultz, Executive Director of Kansas Sentencing Commission, Good afternoon, and the floor is yours.
Good afternoon, Mr. Chairman, members of the committee. Thank you so much for the opportunity to testify on behalf of the Sentencing Commission and in favor of this particular bill. Just kind of give you an idea, my several paragraph testimony that is in writing kind of speaks for itself, but I just kind of wanted to give a little background on how this bill got to you. Back in 2020, OJA as well as KDOC approached the Sentencing Commission and requested that we leap into the 21st century as far as probation supervision is concerned. And by that I mean one of the things that that had not been done up until this point is looking at gender responsive risk and needs assessments. Currently, we use the LSIR, the level of service inventory revised for both males and females. And this philosophy has been in place for many years. We have cutoff schedules or scores that the commission is required by our law to set those cutoff scores, and we do. So both of these entities were very interested in looking at gender responsivity, just simply because mainly on the female side that most of the LSIR data has been validated for males and not for males and females. And so the commission set up an assessment selection committee of 5 individuals and that were members of the commission. We met over a period of many months. We employed the services of experts as far as risk assessments are concerned. We did have, some of you are familiar with Dr. Alex Holsinger from UMKC, that is also a University of Cincinnati fellow. Ashley Bauman, who is also a UC grad, but is also involved in the co-founder of the Women's Risk Needs Assessment, or WRNA. And over a period of months, we actually delved into this particular issue. At the end of the day, the committee unanimously, as well as then it was recommended to the commission, who also reported it out, recommended out unanimously to, as of July 1, 2021, to start utilizing the Women's Risk Needs Assessment for females, or the WRNA, and for males, the level of services case management inventory, or the LSCMI, which is kind of the 2.0, 3.0 version of the LSIR. And so as of July 1, those will actually be used. In fact, both court services and community corrections are training on both of those entities right now. The result of that was that we went back and looked at, excuse me, the SB 123 statute, as well as you'll notice in Section 2, the community corrections placement statute, and those were out of whack based upon the thresholds, as far as the risk level thresholds that are in these new assessments. So to better reflect the changes that have been done there, we are proposing this particular new language that it's, as Natalie indicated, it's kind of a technical change. We're hoping that this may be something that, unless it's, I don't know that there's any reason why it shouldn't be, but we would certainly think that this may be consent calendar type of material. But it's just essentially allowing the commission to do something that it's already been allowed to do in 749101, and then allow us to continue to make those cutoff decisions for risk levels and needs of the offender. And so the bill language in here purports to do that. And we would ask for your support on it. And with that, I'd stand for questions at the appropriate time.
Any questions for Mr. Schultz? And I just one, and Scott, whether it's you or Natalie, whoever knows, if anyone, are there any other places within the criminal code, particularly criminal procedure, I guess, maybe criminal code otherwise, where the specificity in terms of the name of the risk needs assessment that is utilized is referenced, or is it typically rather generic language of utilizing an evidence-based risk needs assessment tool? I'm thinking about the determination of whether one goes on probation versus community corrections. I believe there's a section there that requires a certain level. Are there other areas in the law that we should be concerned with that might be impacted by the switch in this instrument that's being used?
Mr. Chair, that's a great question, and that's something that we looked at as well, and something that the commission looked at with the revisers. And these were the two instances in which a specific risk level was actually indicated. And so we did try and scour the criminal code as well as the criminal procedure code, and these are the two instances that we found.
Mr. Chairman, I might just add a couple things. We don't ever name the risk and needs assessment used in statute. The Sentencing Commission is responsible for deciding which risk and needs assessment to use. And so we just say the risk and needs assessment, determined by the Sentencing Commission. And so they make that determination. And then the cutoff scores for community corrections, that is what we're changing in section 2 there. So that section is actually a part of the bill.
All right, great. Thank you. Committee, other questions? I don't see any. Is there any other proponent testimony? See none. Have no listed opponent testimony. Anybody wishing to testify in opposition? See none. Have no listed neutral testimony. Neutral on this bill. I see none. We'll close the hearing on House Bill 2374. And we'll move on with the remainder of the business that we have scheduled today. At one point in time, we had scheduled today to work 2274, which we were supposed to have a hearing previously, but we didn't. So we'll hold off on that one. I'll not be doing anything there because we haven't heard the bill. 2275, this is up for consideration today. Natalie, would you please refresh your recollection of the committee on the contents of House Bill 2275?
Yes, thank you, Mr. Chairman. House Bill 2275 would require the Department of Corrections to develop guidance to be used by parole officers when they are responding to violations of parole or post-release supervision. And those guidelines would also be required to incentivize compliant behavior of those offenders. I can take any questions.
Any questions for Natalie? I see none. Does the committee have any discussion or amendments to offer or other motions? Representative Heiberger.
Mr. Chairman, I would move that the committee recommend House Bill 2275 favorably for passage.
Representative Heiberger, I wonder if you would consider, because of the nature of this particular bill being that it's simply directing the Department of Corrections to establish standards for post-release supervision and incentivize compliant behavior. It's not being very specific about what that all is. Do you think this might be appropriate for the consent calendar?
Yes, and given that we're back on fairly regular general orders, I'd say I would accept that as a friendly amendment.
Is there a second to the motion to place 2275 on the consent calendar? Representative Owens seconds. Any discussion, committee?
Got just this week to finish up if we're going to work.
Seeing none, Representative Heiberger, you may close.
So if you've got, if there's something out there.
Close and move my motion.
Committee, on the motion to recommend favorably House Bill 2275 for placement on the consent calendar, those supporting the motion indicate by raising your hand.
We're adjourned. See you tomorrow.
Those opposed, you raise your hands. Motion passes with a large majority. Moving on to the next item we had on.
Mr. Chairman, would you please record my affirmative vote?
I guess we can, yes. Affirmative
Thank
vote
you.
by Representative Carmichael, that would be a thumbs up. Representative Heiberger, yes. Representative Owens, yes. Anybody else wishing to have your vote recorded? Seeing none, those aye votes will be recorded. Any no votes wishing to be recorded, if there were any? See none. That will become a part of the record of the proceedings. We'll move on now to House Bill 2277 and ask that the reviser refresh our recollection concerning the content of this bill.
Thank you, Mr. Chairman. House Bill 2277 clarifies the definition of possession as used in the definition section in the Kansas Criminal Code.
Committee questions for the reviser? I see none. What's the will of the committee here? Any amendments or discussion or motions? Representative Owens.
I will move that we pass out House Bill 2277.
Mr. Chairman, I hate to interrupt, but I think that someone maybe is forgetting that they requested an amendment on this bill. So if that jogs anyone's memory. Like possibly even you.
Chairman of Judiciary Committee is now raising his
Okay.
finger. Would that be the one that maybe needs his
Yeah,
memory jogged?
that could, yeah.
Does that work if it's from me? Is this the possession, the two definitions? Yeah, how about we have Natalie explain this amendment?
Thank you, Mr. Chairman. I will share this here. I sent it to Kim, so hopefully it'll come to you guys soon.
You are done.
Those in favor of the amended, oh, I'm sorry, we're not quite there yet.
No, I just have.
And so what this amendment would do, as indicated, I think, this was brought up during the testimony. There is another definition of possession that's found in KSA 215701, which is the definition section that is specific to the controlled substances portion of the criminal code. And right now that definition mirrors what is in the criminal code. And so what this amendment would do is just remove that definition from that section in Article 57. And that would leave just the definition in Article 51 to apply to everything throughout the criminal code.
Representative Patton, is that adequately and accurately stated the intent of your motion to amend?
It does, and I would move my motion to amend.
Is there a second on the motion to amend? Second by Representative Owens. Any discussion on the motion to amend? So just for clarity, Natalie, this just makes sure that we're applying the same definition for the same term throughout any reference where that term might be used in the criminal code.
Yes, that would ensure consistency. There was kind of two options. You could have either mirrored, made the changes that you made in the general definition section in this section, but there's really no need to have it defined twice if both the definitions are just going to be identical. So.
Right. Okay. Any further discussion on the Patton motion to amend? Would you like to close on your motion, or shall we have Natalie do that?
Natalie, you want to close? Thank you, Mr. Chair. I close and move my motion.
Okay, the committee have heard the motion, Patton motion to amend. Those in favor indicate by raising a hand. Those opposed, raise a hand. It appears the Patton motion has passed. And of course, that uniquely removes this from the potential of having gone on the consent calendar, and we'll address who carries this bill later. Are there other motions or discussions on the bill as amended, committee? Is there a motion with respect to the bill as amended? Representative Owens.
Mr. Chairman, I would move that House Bill 2277 be passed out of this committee favorably as amended.
Is there a second? Second, Representative Resmond. Committee, you've heard the motion to pass out and recommend favorably House Bill 2277. Is there further discussion on the motion? Seeing none, you may close.
I close, Mr. Chairman.
Committee, on the motion to recommend favorably as amended House Bill 2277, those voting in favor, please raise a hand. Those opposed? We'll record votes of aye for Representative Carmichael, Representative Heiberger, Representative Owens.
I'm sorry, Mr. Chair, I'm a no on this vote, please.
Oh, I'm sorry.
Thank you.
I tried to sway you. Okay.
I understand.
Carmichael's a
Thank you for your
no.
help.
Representative French is a yes. Any other yes or no votes wishing to be recorded? I see none. I would call upon, though I'll find that the bill has passed as recommended favorably and the vote passed, notwithstanding the naysayers. And we'll call upon Representative Patton, perhaps, would be so kind as to carry House Bill 2277 on behalf of the committee, since it's now being carried. That's good. Thank you, Representative. Committee.
Mr. Chairman, I might add, it's probably a good idea because I would have objected if it was on consent, so.
Well, yeah, it saves time then, doesn't it? Committee, I don't want to unnecessarily rush anything, but I don't want to maybe unnecessarily delay anything either, given we're beginning to really wind down here. I would ask the committee if there would be objection to proceeding to consider the bill of the Sentencing Commission that we just heard regarding the evidence-based risk needs assessment determination by the Sentencing Commission, or would it be your preference to wait until perhaps tomorrow? I really don't care. I don't know that we gain a lot. I don't think it's going to be a meaty thing. Representative French, you want to wait till tomorrow? That's fine. We'll do that. I want to make sure people have time. I don't think it's going to be particularly controversial necessarily, but if people have thoughts or wish to investigate further or offer amendments, certainly we don't want to curtail that potential. That being the case, I believe that we have completed the work for the day. I would encourage you, committee, to carefully review the agenda for the balance of the week. I would like to promise you that Friday at 1:30 we wouldn't be here, but I've not received that promise on judiciary at 3:30 in the afternoon yet. And depending upon progress that is made in ongoing negotiations with the bill that we heard recently, we may have to be here Friday at 1:30 to take care of kind of our last piece of business. If it is avoidable, I will seek to avoid it, but it's possible. So call the chair on Friday at this point. Otherwise, I think we'll have things wrapped up. Is there anything else before the committee this afternoon? Seeing nothing, we'll be adjourned. Thank you.